Hi, I'm Darcel Lobo and I own Dow Law Firm, and today we're going to talk about quiet title actions. What it is, how do you file one, when do you need it, how do you know if you need it, and when should you call an attorney about one? So over my course of years, I've been doing these for about 13 years or so. I've been helping clients with various real estate issues, and a common one among them is filing a quiet title action. Now, how does a client know that they even need a quiet title action? Sometimes they don't, and they're calling an attorney for help because they've learned of something that's wrong with the title to property that they own. So that's usually how this comes about. Either they're trying to get a loan on the property, they're trying to sell the property, and when the title report is pulled, it comes to everyone's attention that there's something on title and it needs to be removed. It should not be there. Most commonly, it is the homeowner did some type of seller financing transaction, maybe 40 plus years ago. It was pretty, common, it seems, in my experience, for financing to be done that way. Maybe in the 60s, 70s, early 80s, it was pretty common, and it still is common now, but I see it a lot from that time frame, from where my client now bought the home 40, 50 years ago, did seller financing, they paid the loan off. Sometimes they have documentation that they paid it off, but the seller at that time never reconveyed, never released the title, never released that deed of trust. It depends on how the transaction was financed, the paperwork on it, but for whatever reason, it didn't get released. And so it still appears that the prior seller has an interest in the property, when in all actuality, they don't. My client, the current homeowner, who's been the homeowner for the 40 or 50 plus years, they paid off that loan. They've been paying all the property taxes. They've been living in the home. They paid all the insurance. That's their house. But we've got to clear up title because that prior seller is still showing on title in some capacity. Now, if we can track down that seller and get them just to sign the release paperwork, that's amazing. And we don't need a quiet title action. That will be sufficient to clear title. Unfortunately, many times either that prior seller can't be found or maybe they passed away. And so now we're stuck with, gosh, how do we get this cleared up? We don't know where the seller is, or they've passed away. There's no surviving spouse. Maybe we don't know who the heirs are. We just don't know. And so we will try to do our initial due diligence to try and track that prior seller down. But if we know they're deceased or they just cannot be located anywhere, then what do we do? That's when we're looking at a quiet title action. A quiet title action is a legal process to remove someone else's interest in a property. And so the timeline for a quiet title action from start to finish, if we do not know where the seller is, and so it's going to take a little bit longer because we have to publish in a newspaper. So it's going to be about a 3 to 4 month process from start to finish for a quiet title action if we cannot locate that seller, the prior seller, and we have to file in the local newspaper for a 60-day response period. So assuming that's the route we have to go, our office is going to get that title report from you or your real estate agent or your mortgage lender to see exactly what's on title. We're going to prepare the quiet title action documents. It actually is a lawsuit that we're going to file in Superior Court, and it's going to be filed in the court where the property is located. So let's say, for instance, if you're in Washington State, and I'm licensed in Washington State, if you live in King County and the house is in King County, then we're going to file in King County. Now, sometimes I might have a client with property in a different county. Maybe it's Grant County, maybe it's Clark County or Kitsap County, wherever it may be. And then even if you live in King County, if the property is located in a different county, then we have to file the lawsuit in that county where the property at issue is located. Nowadays, it's no problem, especially in light of COVID. Most courts have gone to an electronic filing format, or if not, they allow for fax filing, or in a worst case scenario, we're mail filing. Hopefully we're not mail filing, but it depends on what county you're in. But whatever the county may be, we can help you. We can get it filed. There's no problem. And so we prepare the initial paperwork outlining what happened, how we got to where we are. If the client has proof that they paid the loan off, that's great, and so we include that in the filing. I review the documents with you, you will sign them, and then we'll get them filed with the court. When we file the quiet title action with the court, we're also asking the court to approve us to publish this lawsuit, the summons for the lawsuit, in the local newspaper where the property is located. And so that was a 60-day response period from when we file it in that local newspaper. Assuming that we get no responses, no objections, once that 60-day passes, we go back to the court, we submit proof that we did publish it in a newspaper, we include a copy of the publication, and the newspaper will give us an affidavit confirming that they did publish the summons in their newspaper. And so with that, and based on there being no responses, the court will sign the order for us. It's called a default order. So no one responded, and so based on no response, the court is going to give us by default the relief we have requested in those documents for the quiet title action, which means the court is going to approve the order and approve the removal of that item off of your title report, so you can move forward with selling the house, refinancing the house, or whatever you want to do, so that other party's interest is removed from the property so you can proceed forward. So it's very helpful for you as the homeowner. If you have this issue, if you have an issue on title that can't be resolved and you think you might need a quiet title action, go through your books and records, see if you can find any documentation pertaining to the sale of the property to you. And so if you did a seller financing, for instance, and you know you paid it off, many times there would have been an escrow company involved in collecting your payments and paying them to the seller. If you have the documentation from the escrow company on that arrangement, if you have receipts from the escrow company, if you have a letter from the escrow company saying that yes, you paid this off, even if it's, it would have been from many years ago, that's very helpful for me as your attorney in filing the quiet title action. So I'll certainly be asking you, what documentation do you have to support your claim that you did in fact pay this loan off however many years ago? So you'll want to go back to your books and records. Many times the banks, maybe you wrote checks, they're not going to have records from 40+ years ago. It can be very hard to get that, and they might just not have it. And so if you have the paperwork from the sale and showing that you did pay the property off, that's very helpful for me. So please, go through those old, boxes and documents to try and find that, because that's going to be very beneficial for us when we go to file your case and showing the court that yes, you did pay this loan off, and that prior seller's name should be removed from title, or that old deed of trust should be removed from title. Once we have that order, we get that to your title company, and then you move forward. Smooth sailing, title is clear. If you need help with the title issue, give our office a call. Our number is 206-408-8158. Thank you.